Hi, I'm attorney Chris Brown with the Bond Law Firm. Today I want to discuss with you one of the important benefits of trust-based planning that really garners a lot of enthusiasm from people who are considering using trusts in their estate planning. So that benefit that I want to talk to you about is divorce protection, and it's a big deal, especially if any of your beneficiaries ever gets divorced. And with divorce rates as they are in America right now, it's actually not that unlikely, as much as we would wish that it not be the case. And so what I'm talking about in reference to divorce protection is that the assets that you leave behind after your passing, if you set up irrevocable trusts for the benefit of, let's say, your son, daughter, or grandchild, then the assets held in the name of that trust will never pick up community property characteristics because it's owned by the trust, not the individual. And that's going to be hugely important if they ever get divorced, because there's no question whose property is. It's your beneficiary's separate property. Okay, so you might ask, well, geez, can I set this up for myself? Well, unfortunately, no. The reason is let's say you set up a revocable living trust for yourself, or perhaps you and your spouse. So with that revocable living trust, you're the grantor, you're the beneficiary, and you're the trustee. You're in complete control and business as usual. And also, you set up the terms of the trust, you funded the trust, and you're benefiting. It's just you're not afforded these extra protections. However, when you pass those assets along to your beneficiary through an irrevocable trust, what you're doing is, well, let's say, first of all, they did not set the terms of the trust. Secondly, it's not their assets that funded the trust. And lastly, they aren't in control of the trust. It's the trustee who controls the trust. Now, even if the trustee and the beneficiary are the same person, doesn't matter. Legally speaking, they wear different hats. And so really what that means is that they're offered additional protections because they didn't set this up themselves. It was set up for them. And so by law, they're afforded protections that allow them to keep it as separate property. Now, I think this would be a good point to make a little segue to talk about the two different property characterizations in Texas. So there's community property and separate property. And the basic definition is that any property acquired before marriage is considered separate property. And any property acquired during the marriage is considered community property, except gifts, devise, and descent. So those are going to be your three things. And when you hear that, it makes it seem, okay, well, this inheritance should already be separate property, right? That's a huge assumption that most often does not work out the way you plan. And one of the big reasons for that is commingling. And so what commingling is, it's when the separate property assets and the community property assets somehow get intertwined. Let's say they get put into the same bank account, or you own a house and it's sold and the funds get mingled together to buy a new house. Really, the issue becomes eventually that you can no longer trace back the origins of where that money came from to distinguish if it's community or separate property. And the presumption is that it's community property. So, for a quick example, let's say there's a woman with a decently sized brokerage account who is single and she acquired them before marriage, and now she's about to get engaged. And right after the marriage, they, husband and wife, open a joint brokerage account, and the wife puts those stock brokerage account assets that she brought into the marriage into that joint account, and the husband puts in, let's say, a small cash contribution that he is bringing as separate property into the account. Now, right away, it's pretty easy to trace back who brought what into that account. But Do you really think that's going to be the case 5 years later? Think about all of the transactions, stocks being sold, stocks being bought, capital gains. At some point, you can't look at it and trace back where those assets actually came from. And so it's presumed to be community property. Now, if you did want to set something up for yourself to protect your interests as separate property as opposed to community property, then really what you're going to need is either a premarital agreement, a prenuptial, before the marriage, or a marital property agreement during the marriage to distinguish which assets belong to which party of the marriage and which ones belong to both as community property. And it's really a difficult thing to approach a spouse about, to sign off that, hey, this is mine, not yours. But really, in the long run, prenuptials and marital agreements are really beneficial to a couple. First of all, they provide clarity, and also after death, there's not a difficult time for children or beneficiaries to determine whose property was who and who inherits what. It's all very clear. And I only bring that up because we do a lot of prenuptial and marital agreements, marital property agreements here in our office. So if that is something that you would like to consider, then please let us know. However, more importantly, what I want to do is take this opportunity. So this was just one of the many benefits of trust-based planning. There's a bunch of them, and it's all so fact-specific. And there's a large amount of depth that you can go into with talking about trust-based planning. It's a complete and comprehensive replacement for will-based planning. So what I want to do is invite you to call an RSVP for one of our free educational seminars and really get the opportunity to learn more and empower yourself with that knowledge. And then really the best thing you can do for yourself is just not to procrastinate. Procrastination is going to be a killer. So please give us a call, try to attend one of our free educational seminars, but you can also call and make an appointment for a free consultation. We offer a free consultation. Why not do it? And that way, during that consultation, we can get an understanding of the specifics of your situation and also allow an opportunity to develop a relationship. That's one of the biggest parts of having an estate planning attorney, is that you have somebody to call on. You have a guy, or a girl. But it's an important relationship that you should have if you're worried about what's going to happen during your disability or death. So I invite you, in fact I encourage you to please give us a call, schedule an appointment, come to one of our free educational seminars, and we really hope to see you there. Thank you so much, and I hope you have a good day. Bye-bye.